A convicted sexual predator, a youth pastor, a coach once trusted with kids is now in even deeper trouble. Lindsey Whiteside has been hit with federal charges accusing her of transporting a minor across 3 states to commit sexual abuse, and prosecutors say the victim was just 14. This case is escalating fast, and the community is still reeling after a shocking state sentence that made the local DA angry, and that is putting it lightly. We're on the case, presented by Law&Crime. I'm Chris Stewart. Before we get back to this episode of On the Case, I need to take a moment and thank Upside for sponsoring this episode of On the Case. We're talking about a free app that gives you real cash back on daily essentials like gas and groceries. I use it every time I pump gas. Or maybe I go out to lunch, I use Upside, perhaps maybe picking up some gum or Tic Tacs at 7-Eleven or another convenience store. I'm using Upside, so why not get cash back when you do all of these things? And we're talking about real money here, real cash back, money that appears in your Upside app that you can transfer straight into your bank account. Once you have the free Upside app, claim an offer for whatever you're buying on Upside. You pay as usual using a debit or credit card, and then you follow the steps on the app and you get paid. So to find out how much you could earn, click the link in the description to download Upside, or scan the QR code on your screen and use our promo code OTC and get an extra 25 cents back on every gallon on your first tank of gas. That is promo code OTC for an extra 25 cents back on your first gallon of gas. She was already a convicted child predator, but now she's in even deeper trouble. Former youth pastor and basketball coach Lindsey Whiteside, who was just sentenced for sexually abusing a child in her church youth group, has now been hit with federal charges. According to the new indictment, Whiteside is accused of transporting a minor across 3 state lines, Tennessee, Mississippi, and Georgia, to commit sex crimes. And prosecutors say the victim was just 14 years old when the abuse began. At a press conference announcing the charges, the sheriff made it clear what this case means for his county.
We will not tolerate people preying on our children. 34 years of doing this job, whether it be predators, whether it be armed robbers, drug dealers, whatsoever. If you come to DeSoto County to establish any type of criminal organization, we will find you. We will find you and we will hold you accountable. Period. So my message is this: have faith in what we do. We will be relentless in our pursuit of justice. And I say again, justice will always prevail.
The federal charges could bring a much harsher reckoning for Whiteside, and they come just days after her state sentence left parents and prosecutors furious. Now the decision's under fire, and the community that once supported her is reeling. This case started last year in DeSoto County, Mississippi. It's just south of Memphis. Lindsey Whiteside is well known around the community, as well as her family. She's a former college basketball player at Lipscomb University. She later returned home to coach girls basketball at DeSoto Central High School. She was also a student outreach coordinator at Get Well Church in Hernando, Mississippi. It's a Baptist church where she worked closely with kids and teenagers. Now that access, prosecutors say, is exactly what allowed her to prey on a teen girl in her youth group. They say the abuse started in the spring of 2024 and it went on for months. When investigators got involved later that year, they found 64,000 pages of text messages and handwritten letters on church stationery showing Whiteside's relationship with the teen. Whiteside was arrested and charged with sexual battery of a minor. Facing a mountain of evidence, she pleaded guilty. Prosecutors asked for the maximum, 30 years in prison, but the judge saw it differently. He sentenced Whiteside to 3 years of house arrest and 7 years of probation, meaning she would serve her sentence at home. She would have to register as a sex offender for life, but she would never see the inside of a prison cell. Now that is what sparked outrage from parents, advocates, and even the DeSoto County District Attorney himself, and it set off a chain of developments that would take this case in a whole new direction. But before we dive into the fallout and the reactions, there is a major update, because after the state case, Lindsey Whiteside now faces federal charges, further complicating her legal situation. According to the indictment, prosecutors allege that in July of last year, Whiteside knowingly transported a minor across state lines from Tennessee to Mississippi with the intent that the victim engage in sexual activity. A second count involves similar conduct crossing state lines, and a third alleges that from May to November 2024, Whiteside used a facility or means of interstate commerce to persuade, induce, entice, and coerce a minor into sexual activity. Authorities say the victim was just 14 years old when the abuse began. At a press conference announcing the arrest, DeSoto County Sheriff Thomas Tuggle emphasized the seriousness of the charges.
The DeSoto County Sheriff's Office, in partnership with United States Marshal Service, just arrested Lindsey Whiteside on federal charges of transporting a minor across state lines for the purpose of engaging in sexual activity. This arrest is a result of a collaborative investigation involving our office and the United States Attorney's Office. Together, we presented a thorough and compelling case to a federal grand jury. They subsequently returned an indictment against Ms. Whiteside. I want to emphasize that crimes against children will not be tolerated in DeSoto County. We are committed to pursuing justice and protecting the most vulnerable members of our community, our children. Ms. Whiteside has been taken into federal custody. A federal judge will make the determination whether she should be detained pending trial. The DeSoto County Sheriff's Office will continue to protect our citizens and ensure that those who prey on our children are held accountable. Justice will always prevail, regardless if it doesn't look that way. We're going to continue to fight for justice to protect DeSoto County.
Whiteside made her initial federal court appearance on October 24th, pleading not guilty. But the federal case isn't the only story here. The backlash from Whiteside's state sentence has rippled through the community, sparking public outrage and real consequences for those involved. District Attorney Matthew Barton didn't hold back, calling the sentence a miscarriage of justice and laying out the devastating impact on the victim and the community.
This sentence is an absolute abomination of justice. It is not right. It is everything is wrong. This is the reason why people question whether our institutions actually serve victims. This is the wrong message. It is very, very difficult for a victim of a crime, especially a child, to come forward and then to have her voice silenced by a horrible, horrible sentence, miscarriage of justice. Makes it even more difficult for future victims to want to come forward and be brave. I want to commend the victim in this case and her family. I've rarely seen such a display of courage and faith, and I consider it one of the privileges and honors of my career so far to have represented them in this process. I'm very disappointed that we did not get a result that I think was appropriate. But I am very proud that our victim did what she was supposed to, and that was speak up for herself. And even though we did not get the result we wanted, that will never be taken away. Lindsey Whiteside will have to register for the rest of her life as a child sex offender, which will hopefully be a mark to show society that she is the worst type of menace that can never be trusted. This is somebody that was not victim of an overwhelming moment or a temporary lapse in judgment. This is more akin to an adult lioness stalking prey and then pouncing when it was least expected, and then continuing to do so over and over again. Lindsey Whiteside committed sexual crimes against this victim while on church trips, while on a bus with other kids. Put a blanket over the victim and then sexually abused her while in the presence of church leadership and other children, and then preached about Jesus. So we cannot expect children who are victims of crime to tell their teachers or administrators that they have been victimized.
That very public outcry now has real consequences in the courtroom. Judge Andrew Howarth, who sentenced Whiteside to the 3 years of house arrest and 7 years of probation, filed a motion to recuse himself from the state case. In his order, Howarth cited the intense public attention, including Barton's press conferences and statements criticizing the sentence as creating a situation where his ability to remain impartial could reasonably be questioned. In the filing, he wrote, quote, "There is certainly nothing illegal maybe not even unethical or improper, about the manner in which Barton promotes his personal views regarding the disposition of cases. However, since his behavior can result in bringing unusually high attention directed at people involved in the case, including some witnesses, as well as the judge, the ability of the judge to continue to preside impartially over the case might reasonably be questioned regardless of whether such perception is accurate. Effectively, Haworth is stepping aside from Whiteside's case and any future cases prosecuted by Barton's office in DeSoto County, with the Mississippi Supreme Court tasked with appointing a new judge. The outrage over Whiteside's state sentence didn't stop at the courthouse. In the days after her guilty plea and sentencing, it came to light that several community members, including educators and a school board member, had submitted letters in her support. These letters, written before and during the sentencing hearing, painted a very different picture of Whiteside, a former youth pastor and basketball coach who, in the eyes of those writing, had been a positive presence in the lives and in the community. One school board member, Michelle Henley, wrote that Whiteside had worked with her daughter to prepare for middle school basketball tryouts. Parents and advocacy groups called for Henley to resign, saying her support for a convicted sexual predator sent the wrong message to victims, families, and the community. Henley responded publicly saying, quote, "Contrary to what has been claimed, I did not testify for the defense. I was subpoenaed by the district attorney to appear in court. While on the stand, I was asked whether I condoned Lindsey's actions. My response was no. When asked about what her sentence should be, I stated that such a decision was for the judge to determine. My integrity and commitment to the people of DeSoto County remains steadfast." At a special called school board meeting on October 16th, parents packed the room, demanding accountability. Meanwhile, Ashley Ford, a Lewisburg intermediate school teacher who testified in support of Whiteside, was placed on a leave of absence effective October 20th. The district said she would not return for the remainder of the school year, with a certified substitute stepping in for her classes. The superintendent also issued a formal statement clarifying the district's stance, writing, quote, "Even when employees' personal opinions do not align with the district's values, school districts are bound by employment laws that protect due process and clearly define when and how disciplinary action can be taken. With that being said, complying with employment laws does not mean that DeSoto County Schools agrees with or supports the actions of any employee whose behavior conflicts with our core values." And while the community reels from the state case fallout, Whiteside now faces federal charges that take her crimes to a whole new level. Joining us now to talk more about this is former sex crimes prosecutor and former federal prosecutor Rena Paul. Thank you for taking the time to be with us as always here on Law and Crime. A lot to talk about in this case. Just first off, what was your reaction, before we talk about the federal charges that Lindsey Whiteside is facing, on the state charges she was convicted of? What did you make of how little time she actually had to serve? I know she was going to be on house arrest for 3 years.
Yeah, well, thanks for having me. The thing that struck me the most in watching the coverage of the state side was the DA's involvement and his vocal involvement and outrage at the sentence. I thought that was very unusual. He was very personally, it sounded like, outraged about what had happened. Certainly, there was a range in sentencing here, as there always is, between what is the lowest amount allowed and what is the highest amount allowed, right? And when we talk about sentencing, we think about the reasons for sentencing and what those reasons are. Deterrence, whether there's going to be another incident. These are the types of things that different judges look at differently.
And looking at now, so I mean, the DA, you're right. I mean, I haven't seen a news conference like that. I mean, it's maybe not uncommon for a prosecutor to say they were disappointed, but he went scorched earth on even the people who wrote letters of recommendation for her, and that's created some controversy in DeSoto County, Mississippi. From a prosecutorial standpoint, now that she's facing these federal charges, it's for transporting a minor across state lines for sexual abuse. How does that charge compare to the state level sexual battery charges that she was facing?
It's a much more potentially serious charge with a higher maximum sentencing. Of course, it's a second litigation of the same facts. She already has pled guilty in state court to ostensibly those facts, a version of those facts, right? So in a way, it is a more serious allegation and charge.
How does the fact that she pled guilty, she admitted, hey, I did this, and then though she received a sentence the DA didn't like, but she's a convicted sex offender now, how does that factor into how the federal case could play out?
Well, one question I think many viewers would be interested to know is whether this is double jeopardy. We hear about double jeopardy and we think about, doesn't it make sense? Can you still be charged again for the same thing in a different forum? It may seem to some people that seems like that shouldn't happen, right? We already litigated this. Why is it happening again? So, I mean, just from a legal perspective, these are different forums, right? So the double jeopardy clause does not mean that the same person cannot be charged both in the state and in the federal court. They're different sovereigns, they're different charges. And so in that way, she can be charged again. And obviously she is being charged again.
And with the charges she's facing, she's accused of taking a victim across state lines, believed to Georgia, to Tennessee, and then one other state, might be Alabama. How does that factor into, or the better question would be, how does the prosecution, what do they really have to prove? Is it just that she crossed state lines or that illegal activity happened once she crossed state lines?
Yeah, I mean, we look to the indictment into each of the distinct elements of each of the charges that they have pled. So when they plead an indictment, and if it goes into different states, then the proof we expect to see would be evidence of each of the underlying incidents that are alleged in that indictment, if that makes sense. So what we would expect to see if there were a trial would be evidence of each of those states, if they're referenced in the indictment, and the activities that the prosecution or the evidence that they would suggest alleges that happened in those particular states.
Lindsey Whiteside, she was a basketball coach at one point. Her family name had a lot of credibility in the community in DeSoto County, Mississippi. She was the head of this youth group where parents entrusted her with their kids. I know you've prosecuted sex crimes cases. You've seen a lot of people who have done some pretty horrific things. What stands out to you just about kind of the pattern of abuse that she pled guilty to in court?
This case invites a conversation about grooming and the concept of grooming. And people some people have heard of that phrase, and people don't really understand what that phrase means. We see, without speaking directly as to what exactly happened in this case, I think the evidence is still unfolding. But generally, when we talk about grooming, we think about people that are in positions of power and access to children. And the grooming process is a process where such an offender builds trust with the child, and often somebody that's in their care in some way, just begin to normalize sexualized or exploitative behavior, and then create this relationship that allows them access to this child. And I know there was a mention that I saw in one of the coverage of the DA mentioning the term grooming. So even though we didn't see the evidence come out at a trial on the state side, so we don't really know exactly all of the details, it sounds like that's what the DA was saying would have been the evidence of a closening of a relationship. Something in that field is what the prosecutor was suggesting was here.
I know there was a lot of text messages that were exchanged. I know that there were some notes that were exchanged as well. When you are proving a relationship has crossed a line that should never be crossed, what are some of the key pieces of evidence you need as a prosecutor to prove it in court?
A sexual misconduct charge, involving a child or involving an adult, often happens between only two people. So the evidence is different than when there is an assault in a public place and you have many witnesses. Typically, the testimony that you would expect to hear is from one witness and one witness only, which is the person who is reporting the assault. Potentially, there could be some ancillary witnesses, but usually that's it. So we look to other sort of evidence. Text messages and communications are places where we can see the mens rea or the mental state of the offender. So we look to those as investigators, as prosecutors, as defense lawyers, lawyers in general, to see what to make of those things. And, with a child, I have questions about the, social media. This is a place where when we are thinking, working with schools and camps and organizations that have children's programs, working with parents where, something has occurred with their child, as I do now in my work, I see, social media as a place where we look to to understand where there is a possible place for access for people who are looking to access children in this way. So that's another big body of evidence that we look to.
Going back to the state case, and she pleads guilty, and as far as the sentencing, and we were talking a little bit about the range of years that she could have received, but the max being 30 years in prison, but then to only walk away with house arrest, is that uncommon in some of these cases to have such a wide range where it could be as much as, the rest of your life in jail for some people, depending on their age in prison, but then on the flip side of that, being something as low as just house arrest?
Yeah, it's really state dependent. So this is a Mississippi state court. I typically practice in New York state court. So the states and the ranges of potential consequences for state statutes really vary, and sometimes, and it seems like in this case, do give a judge a very wide discretion in the way they want to see the case and sentence an offender to the case, whether that person pled guilty or after a trial. But one thing that you do always tend to see in court when a judge is making that consideration is not just looking at the face of the indictment, right? What they were charged with. That's one piece. But they also look to who the person is and what they can learn about that person. So they tend to do some sort of investigation before a sentencing to figure out, okay, has there been a previous conviction? Are there other kind of mitigating factors that we could be looking at as a judge to try to determine whether or not it's worth this amount of jail time or that amount of jail time? And then, as I said before, really it's a question of what you think. The judge here, I was struck with I believe it was the DA who said that the judge said that prison is for people who scare us. And I was struck by that because that's really a question of, being scared and what you're scared of. That goes to the heart of our criminal justice philosophy. What is prison for? Is it for punishment? Is it for protection? Is it for rehabilitation? Is it for deterrence? Those are real questions that get to the heart of when you have a wide range like this between house arrest and a high amount of time in prison.
When you have a statement like that from a judge at a sentencing that's controversial, and because I think as a parent, I would be scared of someone who would be in, potentially a position to look over my kids, and they would take this type of, that is something that would scare me, and that would be someone I could see wanting to be in prison. After the fact, can that type of statement be used in any sort of review of a judge? Or is it really something, I know that they're elected positions, that's just something you would have to think about going to the ballot box?
Well, one thing as a practitioner, which is what I can speak to best, is, when you think about presenting a case in front of a judge, it does matter, what the way that the judge, you believe or you have seen that a judge will see a case in the past. We look to that as advocates in thinking about appearing before judges. What have they done in the past? What decisions have they made in the past? How do they usually look at a similarly situated case? Certainly for advocates, that's something that people pay attention to.
And then going into, because this was a plea deal that she ended up getting this sentence for, the DA seemed very confident that he had the evidence, if they had gone to trial, that he would have been able to get a conviction. Typically going into a plea deal, do you have a good idea about, even with a wide range of no time in prison, 30 years in prison, what goes into determining, maybe having a good idea of what someone could get if you go through with the plea deal as a prosecutor?
It's a really good question, and it's very varied in my experience, varied by jurisdiction. So here it seems like, given what we discussed about the outrage of the DA, the public outrage by the DA, it seems like the DA did not anticipate that this is what was going to happen, that even walking into court that day, that the DA didn't know that was going to happen. That's not always the case. Sometimes those pre-negotiated plea deals, everybody walks into court expecting something to happen. Ultimately, the decision is for the judge. But many times there is more of an expectation around what you would expect. But it does seem here from what we heard, how the conference, that the DA was really surprised.
And I can see why he was frustrated with everything that he laid out, the evidence in the case, and you can see there's a lot of frustration in the community, and it's important for the community to know what the judicial system is doing, even in the cases that, this one was local news, but maybe not, the national news that some other cases get attention of. At the same time, how would the community of prosecutors look at someone going so scorched earth and naming people who wrote letters, which, one was a member of the school board. And if you're voting for a school board and here's someone who supported it, I could see why that's important for someone to know. But then at the same time, to be that aggressive in the criticism, I guess, how would prosecutors outside of Mississippi kind of look at the way that this district attorney went about it?
One thing I noticed that he spoke about was the decision for that sentence having a negative impact, a chilling impact on the survivors coming forward in the future. And, that is something that not just prosecutors, we all speak about when we speak about the system, the justice system, and how reports of sexual misconduct are handled in the system. So I think it's notable that it seems from listening to what he has to say that was one of his chief concerns, was this chilling effect, the potential for survivors in the county and elsewhere to look and say, oh, well, this is not a place where I'm going to be able to tell my story because it's possible that my story won't be believed. Now, that's one view. I think there's another view that the sentencing of a person from the judge's perspective, it sounded like from what the DA had said in press conference that there was discussion about the judge acknowledging, and there was testimony at the sentencing hearing about what happened. So it doesn't sound, at least from what the DA was expressing, like the judge did not believe that this happened, rather that he took a view of what that meant, and that was the view of what he thought was appropriate for this case, saying nothing about whether or not he believed that the evidence supported the plea deal.
And then just lastly, she's now been indicted on these federal charges. Based on what the charges are, what's the timeline typically between someone being indicted in a case like this and a conviction, potentially?
Oh, good question. Hard to say. Depends on whether or not there's going to be a trial. That can take a while if that's the direction that it's going to go. And less if it's a plea deal. Hard to put a number on it, given the way that these kind of matters move forward.
And the fact that some, and certainly a DA, was frustrated, feeling like she really lucked out and got off, could that have any impact on the type of penalty she could get in a federal case, knowing that there was so much public backlash locally on the state charges?
Once again, I think we'd be in a decision of that judge at that time. And federal sentencing has a lot of investigation that happens before it, and it would be under federal statutes, which are different than state statutes. And so, again, I think we'd be in a situation where we're having analysis by a judge after investigation by both sides and also by the probation department.
And we'll see how it all plays out. Rena Paul, former sex crimes prosecutor, former federal prosecutor, thank you for talking about this story with us. We appreciate it.
Thank you.
Whiteside remains in federal custody while a judge decides whether she will be detained pending trial. She is expected back in court October 28th. That will do it for On the Case, presented by Law&Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.